The lights are not working.
Okay. We're going to take a 5-minute break to try to get our system fixed here. So the court will be in recess for 5 minutes. Thanks.
All right.
We apologize for that. Our next case is number 21-1479, Trappman versus State of Florida.
Thank you, Mr. Chief Justice. May it please the court and counsel. My name is Michael McNamara. I'm the General Counsel of the Public Defender's Office for the Second Judicial Circuit, and I have the privilege of representing David Trappman, the petitioner here. What the petitioner is requesting the court do on this case is to send the case back to the Santa Rosa County Trial Court with instructions to vacate count 2 for double jeopardy grounds and resentence as to count 1. I don't think resentencing is appropriate as to count 3 since that was a first-degree misdemeanor. The court would certainly have imposed the same sentence on that one. The reason is that the First District Court of Appeal erred when it found...
What were the sentences here?
10 years on count 1, 5 years on count 2, 1 year on count 3, everything concurrent.
Everything concurrent.
Everything concurrent, yes, sir.
So count 1 was what?
Aggravated battery on a law enforcement officer. Count 2 was battery on a law enforcement officer.
So count 2 was a third-degree felony?
Yes, sir.
And count 1 was second-degree felony?
I believe count 1 was a first-degree felony.
First-degree felony.
Yes, so maximum punishment, I think his maximum exposure would have been 36 years in the Department of Corrections, and he received 10. The reason that the petitioner believes it should be sent back to the trial court and the First District Court of Appeals opinion should be overruled is because the dual convictions do violate double jeopardy. The reason for that is that the charging document does not allege specifically in count 2 that the battery on the law enforcement officer was a shove. That may have been the state's theory, that may have been what they believed that the evidence showed, but this court has been very clear that when you are doing a double jeopardy analysis, before you reach the distinct acts analysis, you look and you see whether or not the charging document, which is on page 17 of the record, alleges distinct acts. And count 2, the language in count 2 is simply the lesser included language of count 1. The count 1 does allege a deadly weapon. I believe the only actual difference between count 2 and count 1 is in count 1, I believe it says that the actual and intentional touch or strike was against the will of Officer Byrd, and in count 2 it said the actual and intentional touch or strike was without Officer Byrd's consent.
Same double jeopardy analysis if the shove and the dog sicking had been separately alleged, or does it make a practical difference from the standpoint of determining whether or not your client was twice in jeopardy of loss of liberty?
Ultimately, I believe that we'd be able to show that double jeopardy still does bar the conviction had it been properly pled. So under the example you're giving, count 1 does allege the bulldog is the deadly weapon. Had count 2 alleged that the intentional and actual touch or strike had been a shove, then we would move to the distinct acts analysis. And I think that the four factors that are expressed in Parch, which is cited in the briefs, goes through number 1, which is whether there is a temporal break. I don't think the parties disagree that there was not a temporal break. This was, according to Officer Byrd's testimony, he tried to shove Mr. Trappman out of the house. Mr. Trappman responded by shoving him back. Officer Byrd then re-engaged him, started pushing him out of the house, and that's when Mr. Trappman said, "Dog up."
Help me understand, though, how the intention is the same. Obviously, if we take a step back, there is a desire to repel the officer. But I think it's fair to say that the case law is slightly more granular than that, and it would seem to me, and I'm asking you to respond to this, that the intention of the shove is to, push him back, dislocate, whereas the intention of sicking a dog on someone is clearly to inflict grievous bodily harm. It would seem to me like that would be a shift akin to changing weapons in the middle of a battery, which might cause there to be two separate offenses. How do you respond to that?
And then that's number 4, and we can just jump straight to number 4 as far as the considerations. It's not, the language is not that it's the same intent. It is whether a new intent is formed between the acts. So we are limited to looking between the shove and dog up. And in between those two things, is there a change in the intent? And based on the testimony of Officer Byrd, there was no change of intent, because Officer Byrd testified that when they got to the house, they entered, and the two dogs
Why is Officer Byrd's testimony as to the intent a relevant consideration? He's perceiving the actions that are, isn't the relevant intention the intent of the defendant?
Yes, and Officer Byrd's testimony as it relates to what the defendant was doing, because Officer Byrd's observations of the defendant show the defendant's intent. So when the officers arrive at the house, the dogs are milling around. They're walking around the officers. They're not posing any threat at all. Mr. Trappman is combative. He is confrontational with the officers. He's instructed to go outside. He goes outside, and Officer Byrd testified that he has the two dogs out there. He's bashing their heads together. He's riling them up. He's getting them ready to go. I believe when they, according to Officer Byrd and maybe one of the other officers, when they entered the house, Mr. Trappman made some comment to the officers about, I hope my dogs don't bite you. So,
Well, but that all might be indicative of a desire to intimidate and to create fear. But let's put aside this notion of intent for a moment, and let's talk about impulses. Why wouldn't we think of the scenario here be a scenario in which there is a separate impulse which actuates this command to the dog, up dog, which results in it results in the biting of the victim, and that is really what our focus should be on.
well, the focus needs to be on the intent, because the distinct acts analysis is about a change in intent, not a new or separate impulse.
Well, there's some law that talks about impulse, separate impulse.
And
I mean, going all the way back to Blockberger.
well,
Now, I think sometimes there's confusion, and let's just stipulate that our law on this is not, in this area, is not a model of clarity. And sometimes I think there might be a conflation of the notions of impulse and intent. But there is a difference between intention and a volition. Wouldn't you agree?
there can be, yes, I understand your point, Your Honor. Here, though, I think that the issue is very clear, because the charging document does not allege the shove. The charging document, count 2, is just to the lesser included of count 1. The jury instructions, the lesser of count 1, is the exact same language, line for line, sentence for sentence, word for word, verbatim, as count 2. So without the charging document properly alleging it, then you don't even get to the distinct acts analysis. Now, I understand engaging on the distinct acts analysis, but the point about the dog and the impulse to use the dog was present. I would say that is shown by the fact that Mr. Trappman did not leave the dogs out in the yard. The dogs came with him, and the dogs were there in his house. It would be different, I think, if you were to consider the dogs being a gun instead. If he's bringing the gun with him, if he is actively loading the gun and chambering rounds while the officers are in the house, if one of the first things he says to the officers is, "I hope you don't get shot while you're in here," you can say that that's trying to put them in fear, but an assault is just a battery that hasn't happened yet. And when it comes to the language, which is intent, I think that he does have that intent the entire time. When you read the record, when you read the testimony of the officers, it's just, you know, the anxiety is palpable. You know these dogs are going to get used. It's just a question of when, based on them milling about, and particularly Mr. Trappman agitating the dogs out in the yard before he goes back in the house to re-engage with the officers.
Let me just to clarify what happened here. Maybe I'm a little confused with the facts. My understanding is that he was told he couldn't come in. when he tried to come in, the officer told him he couldn't come in, and then he shoved the officer with one hand. And then at that time, the officer shoved back. Did Mr. Trappman, at that point in time, have the pit bull by the collar with the other hand?
I don't remember
I mean, that's
on
why
the
I
record
thought
if that's where it is. If he has
I thought he had
in
the
his
dog
hand.
in one hand, the pit bull in one hand, holding him by the collar, and that's when the officer, shoved the officer shoved him back. He fell kind of back, and he told the dog, do whatever.
And Justice, as I stand here right now, I don't remember that nuance in the testimony.
Okay.
I think that if, let's say he did have the dog by the scruff of the neck, I think is what the testimony
Right.
was, scruff of the neck or the collar, I think that would show even more that he has the intent to use the dog since he brought the dog with him. But dogs are such that you don't need to have physical contact with them in order to order them to do something. You can order a dog to do something from a great distance away, and the dog will act.
Okay. Well, I mean, because what I'm saying is, if that's the case, it seems to be one episode of the shoving back, go dog, as opposed to being shoved back and going to get the dog and coming back, and that would indicate 2 episodes.
I would say that in the second part of the example you gave where he leaves to go retrieve the dog and come back, I think that would still be the same episode, but I think that you would be talking about whether or not distinct acts that the legislature intended to punish differently occurred during that episode. So I think here, because when you run through the analysis for the distinct acts, which again the petitioner says we don't even arrive at since the charging document is insufficient.
Counsel, on this business about the charging document, could you point me to exactly where in your brief you've argued the point about the charging document?
Where in the brief it has been argued that the charging document? I
Yes.
believe we cited in the brief, we cited to Lee, which this court is an opinion from.
I beg your pardon?
We cited to Lee, this court's opinion from 2018, where it it reversed the First District Court of Appeal, which jumped straight to from the information. It skipped over the charging document and right into analyzing the evidence.
Is that in your initial brief?
I don't recall if it's in the initial brief or the reply.
Well, you
brief,
need
but-
to argue things here that are argued in your initial brief, as I'm sure you know.
Yes, sir.
So if you could maybe figure out exactly where that is in your initial brief, it'd be helpful.
Yes, sir.
I'm not saying it's not. I mean,
Yes, sir. I'll take a look at that during my downtime and address it on rebuttal.
Doesn't the text of the battery statute essentially make it a matter of prosecutorial discretion whether to charge, each separate kind of unwanted touching as its own distinct act versus kind of treating it all as a course of conduct? If you just focus on the words of the statute.
It's going to be very fact dependent, but yes, I think there is a broad amount of prosecutorial discretion to charge separate acts in the information. But again, here, the separate acts were not alleged in the information.
Backing up, a quote from Wayland versus United States. Under the question under the double jeopardy clause, whether punishments are multiple is essentially one of legislative intent. So that's where we start. And I'm wondering, as I understand your argument, 775.0214 gives us the answer in this case. Is that correct?
Yes, specifically in 4B, 2 and 3.
And I want to go up to A and look at 4A. It reads, whoever in the course of one criminal transaction or episode commits an act or acts which constitute one or more separate criminal offenses. And here, as I understand your argument, the criminal transaction related to the aggravated battery charge arguably started in the yard when the defendant was exciting the dogs. Is that correct?
Or even earlier than that, when he makes the comment about, I hope my dogs don't bite you.
And then when would that transaction or episode have ended?
When he was tackled in the yard and taken into custody after resisting without violence.
Okay. And you argued in your initial brief that that was one transaction or episode, and I don't believe that the state contradicted that. They agreed with your statement of facts. Is that correct?
I believe the language was that they did agree with the statement of facts, and they had other ones that they wanted to emphasize, but they would do that in their brief, is the position I believe they took in their answer brief.
So your argument is that we have one criminal transaction or episode that constitutes the aggravated battery that temporarily starts in the yard or earlier and then ends when, as you indicated, and then, so whoever in the course of that criminal episode commits an act or acts which constitute one or more separate criminal offenses. So you would argue that the battery that was committed during that temporal period was a separate criminal offense.
The state is arguing that. I'm arguing that it's not. The state could have tried to charge it that way by saying in count 2 the actual and intentional touch or strike was the shove, but since they did not do that in the information, then we don't reach the distinct acts analysis. It's resolved just on the charging document, and count 2 is a lesser of count 1.
Okay. But under the statute, okay, I understand your argument. When you get down to B, when it talks about the specific legislative intent, doesn't it indicate that even if it is considered a separate act under A, because it's an act that's committed as part of one transaction or during the course of one transaction or episode, that it is still subsumed and only one punishment is given because of the defenses or degree variance of one another, or alternatively it's a lesser included?
Yes, either that or alternatively.
Okay.
And
Well, let me ask you about B and what B is really about. Now, if we had a circumstance here where there's no shoving, there's no pushing, there's by your client, maybe he gets shoved, and then his response to that is up dog, up dog. That's it. Now we know that let's just say this: a jury could conclude that the acts involved there constitute a battery, and then based on other things, they could conclude that the act involved there constituted aggravated battery. Isn't that the kind of scenario that B, 4B is designed to deal with, so that your client would not be exposed to the punishment for the battery, which you can't commit the aggravated battery without committing a battery, and your client would not be exposed to the punishment for a battery and the aggravated battery based on that one act. Isn't that what 4B is about?
4B, you have to come back and you have to look at what was charged and what was convicted of.
Well, let's put aside that, because I've looked in your brief. I can't find in your table of cases a reference to Lee. Again, it might be there. That might be a mistake, and unfortunately I don't have my iPad where I could search. But let's put that aside so you can come back and show me where that is. But putting that aside, isn't that what we get to this distinct acts issue? Isn't that what B is about? It's about not doubling up where there's a particular act that constitutes an aggravated level of a crime, but also constitutes the subsumed crime.
And that is a legal question that the court would have to determine afterwards. I think that under the scenario you gave where there was no shove, it's just dog up in response to being pushed out of the door by the officer. The state, I believe the state would have, in their discretion, it would be permissible for them to file the exact information that they filed in this case and allege a lesser included offense as count 2, and then whether or not those two convictions could both stand would be a legal issue for the court to decide afterwards. If the jury felt that count 1 had all of the elements met, then they would necessarily need to find him guilty of count 2 as well, because count 2 is simply a lesser included of count 1.
Counsel, you've used up 3 minutes of your rebuttal time.
Yes, thank you, Chief Justice. I'll reserve the rest.
Good morning. Thank you, Your Honors. My name is David Welch, and I represent the state of Florida in this case. In the state's position, and I believe this court has stated previously in their cases, that the double jeopardy analysis is a 3-step analysis. The first step is, did the offenses occur during the same criminal episode? Different episodes, clearly not double jeopardy. You don't move on. But if it was the same episode, and the state did concede in this case that this transaction was one criminal episode, you have to ask if the offenses were distinct criminal acts. And as the statute states, the intent of the legislator is to convict for each criminal offense during each criminal episode. And you can go back to Blockberger itself, as this court did, I believe, in Graham, and Blockberger looked at the two issues, whether a defendant could be charged more than once under the same statute for multiple acts within the same criminal episode, and two, whether a defendant could be charged under more than one statute for a single act that occurred within one criminal episode.
Can you just run by your understanding of the facts, how this happened?
My understanding is the officers, the three of them arrived at various points to serve a felony warrant on the appellant's wife. He was, I think, demanding to see the warrant. I believe the first officer who responded didn't have it, so that kind of started the confrontation between them. At one point, he goes outside, and that's when the officers say he seems to be riling up the dogs. As I think at some point then, he attempts to come back inside, and that's when Sergeant Byrd initially tries, and I think in his words were, guide him back outside with one arm. The defendant responded to this one-arm guiding by pushing Sergeant Byrd at least hard enough, he said, to knock him back several feet. At this point, Sergeant Byrd responded by, I think he grabbed the appellant with two hands to drive him out, forcibly take him outside, and that's at the time when the appellant said, up dog, up dog.
So where was the dog at that time? Did he have him by the collar?
I don't recall if he was holding him by the collar or if the dog was just the dog was in one of the dogs. It sounds like one of the dogs was in the room. I'm not 100% sure if the appellant was holding him or not. And then the other dog was somewhere else in the house.
So the entire incident occurred when he came back the second time?
Yeah, yes.
That's when the shoving
the two
occurred
acts, yes.
And the dog occurred.
Yes.
Go ahead, finish your answer. I didn't mean to.
Oh no, and so I was going to go back. So if they're two distinct criminal acts, we don't go to Blockberger, the elements test, because I think one of your honors was talking about the elements test would be if it's a single criminal act.
Right.
And so an example of one criminal act I believe this court's used in the past is if I carjack someone while holding a knife, it's one act of I'm holding a knife at someone while I steal their car. Now we look at the elements test, and then I have the holding the knife, the threatening, that's an aggravated assault that requires me to point the knife, whereas carjacking requires me to steal a car. So those have different elements. That's one act, but we allow two punishments for it.
So is, I guess, one way to state the question, which we'll call unit of prosecution, is are you suggesting that when we're trying to decide whether two things are separate units of prosecution, that the test is Blockberger, whether they have different elements, or is there a more nuanced way of determining whether the unit of prosecution is different?
Yeah, it's a more new, and that's where my original point of it's a three-step analysis. So first you look at the episode. If it's different episodes, obviously different charges. Then is it a separate?
So just so we're clear, so obviously the state's position would be that had this defendant done either of the two things, the shove or the up dog, either one of those would be separately chargeable from the standpoint of a unit of prosecution.
Yes, Your Honor, and I believe and borrowing this court's language from Droughty, is it a separate and distinct act by itself? So as the state, if I prove that he shoved the officer, that has nothing to do with my proof that he ordered the dog to attack the officer.
Okay, so then I guess the next question becomes, so there is some universe of different units of prosecution, the simultaneous pursuit of which does not constitute double jeopardy.
Right. Okay.
Help me articulate what the rule is for sorting the wheat from the chaff on those.
Well, unfortunately, I don't think there's a bright line rule. It's going to be very fact specific to the case. You know, you might define act as like a separate impulse of a distinct character, but then you need to look at each individual case, and I think each one's going to be different because, what's the impulse? Is it one victim or are there multiple victims? What's the character and the type of the act? Is there a temporal break? Is the act a necessary and integral part of the other act? Do the locations change, and potentially how it is charging the information? But none of these are definitive. For example, usually if we have two victims, we say, well, that's two different acts.
So what do you think makes it definitive here? Because obviously you're arguing that it is definitive here. What's the change that makes these two things simultaneously chargeable and prosecutable as separate units of prosecution?
Well, I think in here, different impulses, different character, the nature and the type and character of the acts are different. Me shoving someone is different than me ordering a larger dog to attack someone and bite them, and I believe he still had scars over a year later from the attack. So it was obviously somewhat serious. And again,
that's the aggravated battery.
Yes, Your Honor. And again, it goes back to, if I prove the shove, I haven't proved the dog attack, and if I prove the dog attack, I haven't proved the shove. They require different elements of proof from the testimony here. And then the temporal break, it's something you look at, but it's not necessarily definitive, because if you look at a case like Droughty with a sexual assault where it was simultaneous, where you had the lewd and lascivious touching and the penetration occurred simultaneously, but then on the other hand, you could have a theft type case where that's going to take place over a period of time, but it's the same, if it's one victim, you're stealing all their stuff, it's the same impulse to steal. So there, again, you have to look at it individually. And then even victims. Usually, if you shoot two people, two victims, that's going to be two separate charges. However, there was that case with cattle theft where it was the cattle belonged to two individual owners, but they were in the same field. So it was one impulse to steal the cattle from that field. So again, it's not definitive. It's going to be case by case. And here, he was charged with the aggravated assault for the dog, and he was charged with just or aggravated battery, excuse me, and then he was charged with the battery for the shove. The testimony proved that both occurred.
See, my concern is that we sit here and analyze the facts of this case in slow motion.
Right.
I mean, this is happening like this. And that, in my mind, determines what is one episode or not. I mean, if it's happening quickly, he shoves the officer shoves back, suddenly, go get him, dog. It seems to be happening really quickly.
Right, and that is a factor to consider, but again, like I said in Droughty, or this court said in Droughty, the acts can be simultaneous, or, in a case where we have two victims, if someone shoots both and it's two bang, bang, two trigger pulls immediately after each other, each trigger pull would be a different impulse in a separate and distinct act. Right. As opposed to...
Would that, the two shots, is that the same victim or two victims?
It could be, if it's two victims, it's easy, potentially. But then, as a counterexample, it would depend on the type of gun used and the setting used. So if it was a semi-automatic pistol and you have two trigger pulls, that's two separate acts. But say I have an assault rifle that's set to a burst mode, I pull the trigger, 3 or more bullets come out, that's one trigger pull, that's one act. Potentially if they hit the same person, you would have one charge, and potentially even if they hit two people, depending on the rest of the facts, you potentially have one charge because there's only the one single trigger pull, and that's why it's not a bright line rule. Each case you're going to have to go back and look at the specific factors.
Can I ask you to not think about the facts of this case or any other case for a minute and look at the elements of the two crimes that were charged and at issue in this case, aggravated battery and battery? And would you agree that battery is subsumed within aggravated battery? If you've committed an aggravated battery, you've necessarily committed a battery.
Yes, I would agree with that. And if we were to get to the third step, the Blockburger, because we have a single act, then you would run into a double. So, for example, if I were to if a defendant were to
So,
punch.
and another way to say that is that the aggravated battery statute doesn't require proof of an element that the battery statute does. Right.
Right.
Okay.
And if you're a single act, so a defendant punches a 70-year-old, they're going to be, they're not simultaneously going to be convicted of a battery of someone over 65
Right. Okay.
and just a battery.
So thinking still generally about the law and what the statute lays out as the offenses, and we have here, and I'm going back to 775-0214A, whoever in the course of one criminal transaction or episode, you've conceded that there's one larger criminal transaction or episode, that's the one that was charged as the aggravated battery. The defendant commits an act or acts which constitute one or more separate criminal episodes. We have that. Separate criminal offenses.
Right.
So he did commit a battery, and during the course of the battery, then the legislature says that they should be punished separately if they are separate offenses. And then it says, for purposes of this subsection, offenses are separate if each offense requires proof of an element that the other does not, without regard to the accusatory pleading or the proof adduced at trial. So in this case, because aggravated battery is separate under that definition, it's completely subsumed, why isn't this statute, subsection A, telling us that because it was one criminal transaction or episode, both acts are not treated as separate because they're not separate under the definition?
Well, I believe in this case, the different element of proof would be the dog attack versus the shove. Those are different.
But the statute's talking about without regard to the accusatory pleading or proof adduced at trial. We're talking about when we're deciding whether something is separate under subsection A, it's very clear the legislature says only look at the statute and the elements of the offenses and whether one is completely subsumed within the other. I mean, that's what the statute says.
Right, and that would be for one single act, but under
No,
that.
what it says, it's for any act that's committed during one criminal transaction or episode.
Yes, for any single act should be, but separate acts should be punished separately. Otherwise,
But then it gives you the definition of separate, and that definition says don't look at the facts at trial at all. Look only at the statutes, and if one is subsumed within the other, then it's not separate. I mean, I don't know how you can read subsection A.
well, then that would invalidate Blockberger itself, because there they said this is one criminal episode, and it was a series of similar charges of drug transactions over several days. And
well, but then you look at whether it's one transaction or episode. If there's a temporal break, that kind of thing. I mean, that would be.
Well, and going to Blockberger, they said these series of drug transactions are one episode.
But if it's an issue of legislative intent under the double jeopardy clause, and the Florida legislature has answered the question in this case in 775-0214A, why would we look anywhere else?
Because, again, Your Honor, by that the interpretation you're potentially saying skips the second part of the analysis. It would
The
just
second part of the analysis according to the statute? Where is that in the statute?
Well, the statute said is the intent of the legislator for each criminal offense to be punished separately during each episode. I don't believe it's the legislator's intent to create a situation that as long as I commit the same offense over and over and over again, I only get punished once for it.
I think this is an interesting question of interpretation of this statute. I think what Justice Lawson is suggesting is that essentially that provision should be read as saying offenses are separate only if each offense requires proof of an element that the other does not. And I think the question is whether that's the proper way to read it when you look at it in context of what goes before and this expression of the legislative intent to punish for every separate offense.
Right.
And whether this is a specification that's exclusive, or this is just specifying a circumstance in which offenses are separate.
Right, and I agree with that. And I think this court provides an example in Droughty when it talks about how the molestation of groping the victim's breast was a separate and distinct act from the penetration. and then gives a counterexample saying that, like, in the course of the penetration, if the defendant had groped the victim's buttocks to assist in the penetration, that's not a separate and distinct act because it's an act in furtherance of the penetration versus whereas the groping, you don't have to do one to do the other.
I'm sorry to interrupt you. Can I ask you a question? So if we take the battery statute as it's written and we take the Blockberger implementing statute as it's written, is it permissible if you have a situation where there's a fight, there's only one victim, and there are 10 punches thrown, could the state charge 10 different crimes? And if there's proof that if the jury believes that 10 blows,
potentially you could, if you could prove that each one was a different impulse. And I think a good example of that would be.
I'm sorry. Okay. And so where does the impulse? Where does that? Are you getting that from the case law, or where? I'm trying to understand if that's a textual thing or where, because I'm trying to understand what makes this case different from a single fight where 2 punches are landed.
I believe the impulse language, and I don't have the exact quote, comes from Blockberger itself, and
that is definitely in Blockberger.
So
yeah, and I was going to say it's rather archaic, so it's a little harder to memorize.
So it's basically, and I'm not saying that that's wrong, but basically you have to sort of read Blockberger, read the statutes. There's nothing, you would point to textually that kind of leads you down that path.
Outside of the intent is to punish each criminal offense within each episode. Going back a little easier, if I hold up a defendant robs a bank and there's 10 victims and he goes to each person and robs them individually, that's 10 individual robberies.
Why wouldn't you answer that question in terms of the? Go ahead.
But counsel, for the state to prevail in this case, the court would not have to adopt a per touch theory. I mean, this is a different kind of circumstance.
Right, and like I said, there's no bright line rule.
Because you're almost out of time, be as clear as possible, though, as to what is the principal distinction. I think everybody's worried about a per touch thing, or everyone would want to know that that's the, if that was the implication of whatever gets decided here. But what is it about? Can you be as clear as possible and say what is the rule that we would articulate that would separate this case from a, one fight, 2 punches equals 2 crimes?
Well, and I don't know if you could necessarily completely separate them, because there would be potential circumstances where multiple punches would be 2 offenses, similar to the first district's opinion in Mercer, where you had a punch and then it was a punch and then a kick.
But those were administered by 2 different people.
Right.
I mean, one is as a principal and one as, that's.
And here you could argue he is a principal to the dog attack by ordering the dog to attack, and he physically pushed the officer himself. I mean, it's not a perfect analysis, but it's similar.
So the dog is, it's like.
But I think here you would have to, the court should articulate that it's a 3-part test. First, is it the same criminal episode or not? If it's different criminal episodes, you don't move on. Second, is it a distinct criminal act? Is it a separate impulse of a distinct character? If it is a distinct criminal act, you don't move on.
Why are you even conceding that it's the same criminal episode?
Yeah, I was going to ask that too.
Because I think you have the same victim, and we're talking about a minute of time. It's an action by the officer, a reaction by the appellant.
Well, you're conceding that partly because it was conceded in the district court, I would assume. That's been conceded throughout, right?
And I think here, I mean, I think it would be hard to articulate that this would be 2 distinct episodes, and I think that's the confusion that some courts have caused before.
Wouldn't it be more simpler just to apply the plain language of the statute? Because we're talking, whoever in the course of a criminal transaction or episode, we know here we have the larger criminal transaction or episode, a person commits an act or acts that constitute separate criminal offenses. We know we have that scenario here.
Right.
And so if the statute gives the answer in the framework in which the statute talks about the legal issue, why would we add an additional why we talk about whether one of the acts that we're talking about is a distinct act. What does this judicially created look at something else make sense given the plain language of the statute?
Well, I think what we're saying is distinct act is mirroring the statute. And that
a distinct act would be an act, right? Whether it's distinct or not. So if it happens during the course of a different criminal transaction, in this case the aggravated battery, it can be a distinct act, but it's still an act. And the statute tells you what to do with an act, depending on whether it's separate or not.
Yes, and I believe that's what the state is arguing here. If it's separate acts, and again, this is a distinction between, like the Rivera case, where potentially you had someone stabbing and punching in the same act. It was like,
so, but again, I know you're out of time, but for purposes of this subsection, offenses are separate if each offense requires proof of an element that the other does not, without regard to the facts of the case or the accusatory pleading. Under that definition, are they separate?
yes, because otherwise you would end up in the situation
Well,
where...
wait. No, I mean, you conceded earlier that one was consumed, the elements of one were consumed within the other when you look only at the statutes. Don't consider, as statute directs, the proof at trial, what happened, what didn't happen.
Right, but under that, if you were to take that to the extreme, Your Honor, you would have a case like Blockberger where you had the same charge, where they're the exact same elements, but they were able to stood because they were different acts.
Was the United States Supreme Court applying 7750214 in Blockberger?
No, but 77204 was adopted in Blockberger as a standard. And again, you would end up in this situation where I could never charge you with the same offense, even if they are distinct acts, because they're the exact same elements. So if
No, if they're separate criminal transactions or episodes, you could, correct?
Well, I think there's
So, for example, you have the simplest of batteries, do not touch me, and the person touches you 3 times. One transaction or 2?
I think one transaction with 3 acts.
You have another circumstance where the person says, do not touch me. There, I touched you. I dare you to do that again. Do not touch me. Two or one criminal episodes?
The state's position there is potentially you have one episode with 2 distinct acts.
Even with the temporal break and the different intent? The formulation of a new intent to touch a second time?
Well, I think that's what makes it a new act, is a new intent, or a new, not necessarily a new intent, but a new impulse. Okay. Because again, in Blockberger, a series of drug transactions, arguably, that's all the same intent to sell the drugs, but each transaction was a new impulse. And for the reasons argued now and in our brief, the state asks this court to uphold the First District's decision. Thank you.
The state's concession to a single criminal episode does allow this court to resolve the issue here with the statute. Justice Kennedy, I told you I'd get back to you on the citation on Lee. Lee is cited in the respondent's answer brief. You are correct that it is not on the table of cases cited in the petitioner's initial brief.
You didn't really argue this issue about the way that it was charged in your initial brief.
The state...
You made an argument here where you started off relying on the way the state charged the case. And you said that you should prevail on that. And what I asked you, you mentioned a case, but what I specifically asked you also was where you argued that in your initial brief. And if you didn't argue it in the initial brief, just say you didn't. If you did, point me to where it was.
I don't see in the initial brief where the argument was made. The initial brief discusses the distinct acts issue, which is
okay. So you didn't make that argument. The argument you started off with, the oral argument, was an argument that was not made in the initial brief.
The argument of moving past the charging document and into the distinct acts, I think, is what the initial brief centers on, and it talks a lot about the initial brief. The initial brief talks a lot about how it's a single criminal episode and how these are not distinct acts.
Well, I know that. I know that.
Yes,
I read the brief. But what mystified me when I heard your argument, I said, did I miss that in the brief? And now I found out I didn't miss it in the brief. You were just arguing something that wasn't in the brief, correct?
And And there was a lot of talk about the testimony in the brief.
I understand.
And how it comes back to, the testimony at the trial cannot cure what is a charging defect in the record.
Counsel, I just, if you didn't argue it, you didn't argue it. But we can move on.
Counsel, you can have 30 seconds to sum up.
Thank you, Chief Justice. The exception to the legislative intent to convict and sentence for each offense doesn't apply where the offenses are the lesser offenses and the statutory elements of which are subsumed by the greater offense. That is what we have here, and it does conflict with what the 4th District did in Olivard. That's why this court has jurisdiction, and that's why this court should grant the relief that I requested at the beginning of my oral argument. Thank you.
Thank you.
All right.